Good afternoon, everyone. I hope this message finds you fit and fine. So today we are meeting to complete part 4 of Indian Constitution, that is DPSP, Directive Principles of State Policy. So considering that you have gone through the previous lecture in which we discussed feature part of DPSP, right? Now let's start with a question. So my purpose is that you should think and use this lecture so that you can answer questions comfortably in exam. So one probable mains question can be, critically analyze the status of DPSPs as enshrined in Indian Constitution. I am repeating, critically analyze the status of DPSPs as enshrined in Indian Constitution. Full stop. And question can be 15 marks, 200 words. Now on this point you should think, critically analyze. So do you have some points? And they should not be just points, they should be arguments. And to score more, your argument should be backed by certain people, popular people. When we are talking about a constitution, so you can quote some members of Constituent Assembly, what their opinion was on the status of DPSPs. Okay, so this is one type of question. And by the end of this video, we will be done with the discussion on these points. Now, second question. Discuss the debate between fundamental rights and DPSPs, comma. In your opinion, they are complementary as well as contradictory in nature. Discuss in your opinion. Yeah, what can be done? That they can remove this word in opinion and they can simply use the statement. Discuss the status of fundamental rights and DPSPs and their nature being complementary as well as contradictory. So now, while answering this question, you should not just focus on the provisions part, okay? Because this question is about means, right? So there you need to talk about the substantive part, means the very idea which differentiates fundamental right to this DPSP. So means we need to bring the debate of political rights, civil right at one end, socio-economic rights at another end. We need to also bring the debate or the principles of justice as mentioned in preamble. So by these 2 points, I think now you are a bit clear that when these kind of questions are asked, you should not just focus on provisions which are mentioned in part 3, part 4. Okay, this understanding need to be reflected. Okay, now when it comes to prelims part, from DPSP, one common kind of question is, which of the following is not a DPSP mentioned in Indian Constitution? So this is obviously can be covered when you have gone through the previous lecture. You have gone through the features, or you can say parts which are mentioned in DPSP. Now, another more important is, a question can be on cases which are related to status of DPSP. So one prelims question can be on the cases. For example, according to Champakam Durai Rajan case, DPSPs were given primacy over fundamental right. So this is one statement. So how can you answer? You can only answer when you know, okay, the whole trajectory, Champakam Durai Rajan case, what it said. Then what was first Constitutional Amendment Act, 7th Constitutional Amendment Act. Thereafter, how Golaknath's case was totally different from the opinion which was raised in Champakam Durai Rajan case. And after Golaknath case, what was the status of DPSP as per Kesavanand Bharti case? And along with this, you should connect what Article 31C was saying about it. Okay, so if this trajectory is clear in your mind, then you can answer this kind of question, means second dimension of the prelims question easily. Okay, now third part. Third part is applicability part, which is becoming a, you can say, a favorite part of UPSC nowadays. You can check the questions which were asked last year. Means some questions will be checking the fundamental aspects, whether you are clear about this or not. For example, when you open your Lakshmikant, so in the critical part, there's a word that DPSPs are conservative in nature. Okay, and there's an explanation also in your Lakshmikant that that these DPSPs were inspired from English socialists, right? For example, Sidney and Beatrice Webb, right? And this word Fabian socialism is mentioned, that Fabian socialism is reflected in DPSPs, and in this particular part, it is used as a limitation. Now, what UPSC is going to play on, they will actually connect Fabian socialism, its limitation, with the status of DPSPs. So you can easily answer such kind of question, which many students are going to get trapped in, if you understand what is Fabian socialism and how relevant it is in present context. Means how it is related to DPSPs, whether it's a limitation or there are some positive, you can say, connotation to that also, right? So it means whenever you start a topic, my advice is keep in mind the kind of questions which can be asked in prelims, kind of questions which can be asked in mains. And how you can do that? You can easily do that, just go through the previous year question papers, okay? Now, let's start this discussion. Welcome Manjeet, welcome everyone. So you can share this discussion with your friends or group so that other can also engage in this discussion. So DPSP is part 4, 36 to 51. So let's start with a trap question, okay? Let's have a good start. So I'm making a statement and you have to tell me the statement is true or false. This is our signature style, okay? So that I can be sure that all of you are, on the right track in your preparation. Statement is, judiciary is not considered as a state as mentioned under Article 12. So I'm repeating my statement that judiciary is not considered under the definition of state as mentioned in Article 12. Why I'm making this statement at this point? Because in previous session I mentioned Article 36, and Article 36 I told you that Article 36 says the definition of state is same as mentioned in Article 12, right? And I told you what is mentioned in Article 12. That's union legislature as well as executive, state legislature, executive, local government bodies, and fourth was other bodies, right? And other bodies which have regulating function as state. We discussed in Article 12 as well. So now I have made a statement that judiciary, now tell me, because the word judiciary is not mentioned in Article 12, and if it is not mentioned in Article 12 and Article 36 in DPSP says definition is same as Article 12. Now my point is, since it is not mentioned in Article 12, whether judiciary is considered as a state in Article 12 or not. So you have to answer me true or false. Come on, this is how we are going to start. Welcome Bhumej, Badal, Rahul, welcome everyone. And everyone has to answer, okay? I have no expectations from you at this point of time, okay? Purpose is that if you are going to commit mistake, you will get the right answer, and then you are not going to commit this mistake in exam. That is the only purpose. Every answer is going to be respected. Now, come on. First, judiciary as a state or not? Tell me. Come on. Answer is that the question statement was saying judiciary is not, right? It means answer is false, because in judiciary we can say there are two functions of judiciary. Means judiciary also has two functions. One is administrative and other is judicial. So my friends, please remember, judicial wing of judiciary is not considered as state under Article 12. And what is the meaning of this administrative and judiciary? Whenever you are going to go to court, okay, so you will find that there is an administrative staff also. Consider, say, High Court. So High Court is having a dedicated secretariat also. Supreme Court is having a dedicated secretariat also. So there is administrative staff, and they also make certain policies. They also conduct recruitment drive, right? So that is administrative function. For example, when it comes to vacancies in High Court, so our constitution allows this, that High Court is going to coordinate with State Public Service Commission regarding these vacancies in High Court. So at this point, High Court is having administrative function, okay? But in case Sunil Nayak has committed some crime and his case is being heard in High Court, so when High Court is listening to the arguments of advocate and now going to pronounce the judgment, that is judicial function of High Court, judicial function of court. So judicial function is not considered as a state in Article 12, but when it comes to administrative function, it is considered as a state. Means this segment of judiciary is considered as state under Article 12. If this is clear to you, mention yes in comments. Now let's move forward. So now this topic, sanctions behind DPSPs. It means why DPSPs were given such status. Means non-justiciable, right? So you cannot go to court. Why? So before talking about the, you can say, reasons part, you should also know about certain popular comments which are made by constituent assembly members. For example, Mr. K.T. Shah, so he said DPSPs are like check, means such a check which is given to the people, but this check will be only encashed when bank is going to have the cash. Means it is going to be on the prerogative of bank whether bank wants to give you money or not, and also at what time bank wants to give you money or not. So this is actually like a check. He also used another word, that DPSPs are like pious superfluities. It means there are good words, means good ideas, good ideals, principles. But when it comes to its implementation and the status, it seems like it is way beyond the practical reality. The need is that they should be implemented, but अच्छी बातें हैं, but implementation से तो they are very far. Okay. Now, when it comes to B.R. Ambedkar, so B.R. Ambedkar used DPSPs he commented on DPSPs in positive context. He used novel principles as a word. Okay, but now we are just focusing on critique part, because in the starting of this lecture, I asked you one question: critically analyze the status of DPSPs in Indian Constitution. And there I told you that you should not just focus on what is mentioned in DPSP, you should focus on giving argument. So you can use the argument of Mr. K.T. Shah. Okay. Apart from that, you can also mention Mr. Nasiruddin. So Mr. Nasiruddin said that these DPSPs, they are like New Year resolution. These are like New Year resolution. And what happens to New Year resolution? All of you know that what happens? They actually get break on the very next day. I'm not saying this is with everyone, but this is the popular reality, that these are like New Year resolution. Okay. Another Constituent Assembly member, Mr. T.T. Krishnamachari, I'm writing TTK. So he said that DPSPs are like veritable dustbin. It means good ideas are there, but the status is such that they are reduced to a dustbin. It means no one is going to pick things from this dustbin. But this is veritable. Veritable means very important. Its status is important. But due to the kind of conditions we have put, that this is like a veritable dustbin. Okay. So I hope you will remember these. Okay. Now, you should also, since question is talking about critically analyze, so obviously we need to have some critical points in mind. But please remember, the word is analyze. It means we have to balance our answer also. So what argument you are going to use there? So as of now, I'm talking about quote, and thereafter, when we discuss further, you are also going to get the argument. Okay, quote. So in quote, you can use Mr. B.R. Ambedkar, who was having high hopes from DPSPs, because he was saying, B.R. Ambedkar was saying, I am just writing it down here. B.R. Ambedkar was saying that they are going to bring social and economic democracy. I hope you are writing them down, right? The whole trajectory of the lecture should be there in your notes as some, you can say, keywords. Okay, I'm not saying write everything, but keywords. So he said socio-economic democracy is going to be the product from DPSPs, because when it comes to political democracy, it can be ensured through fundamental rights. Okay, socio-economic democracy as well as noble principles. Okay, there's another famous scholar, Mr. Granville Austin. So he was saying that DPSPs along with fundamental rights represent the conscience of Indian Constitution. Okay, K.C. Vihre. Conscience, he was using the word conscience. Okay, and please remember that UPSC may actually make a question. On one side, they will mention the name of these people. On the other side, they will mention the popular comments and ask you to match the following. Okay, so in this scenario, you should be well versed with this dimension of question. Okay, now coming to the point, why they were made non-enforceable. So you can easily remember, they do not possess sufficient financial resources. It means we were just getting independence, right? And we were not having enough financial resources. If Indian Constitution would have given them the status equal to fundamental rights, then it could have created legal issues, right? For example, if fundamental right is abridged, you can knock the door of Supreme Court, right? But in this case, socio-economic right, a huge financial burden needs to be taken by state, and state was not having that kind of capacity at that point of time. Vast diversity and backwardness. And due to this vast backwardness of Indian society, the implementation part was not that much easy. So those who are wondering, what is this? Please remember, law, legitimacy of law is only when it is in consonance with the social reality. Please write this statement down, because when you write these kind of statements in your answer, it increases the legitimacy of your answer. Okay, what I said, that legitimacy of law enhances when it is in consonance with social reality. For example, in fundamental rights, I mentioned Article 17, untouchability. Okay, prohibition of untouchability, right? And we also have laws made by Parliament which talks about prohibition of untouchability. But tell me, in reality, do you think this untouchability is prohibited in Indian society in practical scenario? No, right? We still have certain instances where this discrimination happens, right? So now, don't you think if social reality is different and people are not changing, and those when this law is saying that this is wrong, so one section of people belonging to a particular caste, so-called upper caste, they can say that, oh, you are intervening in my life. My religion says that that this discrimination is justified. So if they are saying this discrimination is justified, so what does it mean? It means social reality is different from legal reality, and when they both work in consonance, then we find that there is legitimacy to that law, implementation to that law. If every one of you agree to this part, mention agree. It is clear to you? Yes, KM Parikar also said DPSP is bringing socialism in economic sphere. Now, to reduce the burden of newly formed India, because we were just formed and we already had so many challenges on political front, right? So at that point of time, it was conceived that social and economic front will also be taken care by Indian state in phased manner, right? Now, criticism. So 1, 2, 3 and 4, and within 4th we are going to discuss further, okay, because in 4th we are going to discuss these. So there are 4 prominent criticism of DPSP that you are going to use in critically analyzed part, okay, but you should not just write no legal force, okay, you should also talk about what does it mean, right? And why, and since it is analyzed, you should also talk about why such provision, why such status was given. So no legal force, it is quite clear that as it is mentioned in our constitution, it doesn't mean that it is legally in force, right? But why the status was given? These were the reason, right? Why this was not legally enforceable. But since it is analyzed, you can also mention that door of its enforceability, although was open as per the direction given to the state, and state is going to make the law, okay? And within this, you should also mention some arguments. For example, Mr. B.R. Ambedkar was of the view that since we are going to have a government based on popular vote, no government can actually take this risk of sidelining the principles of DPSPs. Because these DPSPs, they represent the aims and aspirations of the people. Aims and aspirations of the people. So any government who will try to sideline the aims and aspirations of the people, they are going to give this response to this particular party who is having government in the next elections. So by this logic, even if they are not given legal force, but this does not mean they will not having any value. So use this line. It means no legal force does not mean they will not have any value. Value will remain because representing aims and aspirations, and we have popular government, right, responsible to the people. Now, because when I'm going to talk about parliament, then we are going to discuss this word responsible in detail, because responsible word has different connotation when we talk about parliamentary form of government. But B.R. Ambedkar was talking that, yeah, since people are the one who have given you vote, you need to give respect to the aims and aspirations which they have. Now, illogically arranged, it means no coherent philosophical structuring was given to part 4. What does it mean? If you go through the previous lecture, you'll find first we were discussing socialist principles, and within socialist principle, some principle, for example, Article 40. So we picked Article 40 from there and we discussed it separately under Gandhian principles. So the logic says that some crucial provisions were actually placed with not so important provisions. It means no coherence is there on philosophical line, ideological line, as well as importance line, right? So these are the 3 things on the basis of which they are considered illogical. Okay, these 3 things need to be mentioned. Okay, now conservative. Why conservative? Because it is said that ghost of Sidney and Beatrice Webb. Sidney and Beatrice Webb, have you heard about them? Actually, these were husband and wife, and these were famous scholars, English socialist scholars, means British socialist scholars. and they were the earliest member of Fabian Socialist Society in Britain. And my friends, UPSC is asking questions on these details nowadays. Now, Fabian Socialist. And why Ghost? If you take a look over the education profile of many prominent members of Constituent Assembly, where they studied, simple answer is Britain. Our first Prime Minister, Mr. Jawaharlal Nehru. Jawaharlal Nehru also accepted that he is a Fabian Socialist. So what is the meaning of Fabian Socialist? This should be a question coming into your mind. Let's break this word into two parts. Fabian Socialist. Okay. Fabian word comes from the word Fabius, King Fabius, whose idea was by adequate intervention of laws, equality, social well-being can prevail. And socialist as an idea, it stands for bringing equality, right? So it means Fabian socialists actually have this idea that if inequality is increasing in society, so solution is not to overthrow the government by having weapons in hand, like these Maoist support, Naxalist support, right? We have to take up arm and power flows through the barrel of gun, and that's how we are going to bring the socialism we want. But Fabian socialists said no need of violence. Without violence also we can bring this socialism. And how we can bring? Government means state can make this possible by making certain laws. Now some of you might be thinking, this is such a good thing. Then why we are using the word conservative with it? Because ideas were good. But idea says state will make such policies. But in our constitution, the status of DPSP is non-justiciable. It means it is not necessary for the state to make such policy. So that is why it is said that idea was good, but we were playing too conservative with regard to the possibility which could have been generated by making it proactive, making DPSP provisions proactive. Okay? So if you are clear with the discussion until now, mention clear. And you can also mention ultra clear or ultra clear max. Okay, now constitutional conflict. What does it mean? Means the presence of DPSP also gives a scope of conflict. For example, President and Prime Minister. Consider that Parliament has passed a bill, means consider Lok Sabha, Rajya Sabha has passed a bill, because when we use the word Parliament, it means Lok Sabha, Rajya Sabha and President. Okay, so Lok Sabha, Rajya Sabha passed the bill, and now this bill needs to be presented to Honorable President. But Honorable President finds that, oh, this bill is devoid of this DPSP, right? So in this context, President can actually obstruct the passage of this bill, and obstructing the passage of this bill will represent constitutional conflict. Okay, so it means the center can give direction to the so this is between center and state. Yeah, this is the point which I was discussing between the President and the Prime Minister. I'm going to come to that also. So in this case, constitutional conflict may occur. President will say, oh, DPSPs are not enshrined in this, right? This is devoid of, or this is in direct conflict of DPSP provision. So this can happen. So the ministry has no right to ignore them. They have to, take them into consideration. Another is between center and state. It simply means center can give direction to the state that this is mentioned in DPSP, and that is why we are giving you direction that you have to do this. You have to make such law. You have to bring such administrative change. But in case state says, no, we are not going to do that. In this scenario, center can actually exercise the power under Article 365, and by this manner, they can actually change the government there. Means they can impose president, you can say president rule. So dismiss the state government in this scenario. So this can be considered as misuse of this particular provision, DPSP part, right? You can consider that this can create a constitutional conflict because state government will say, no, our opinion is different when it comes to this law. Why we should be bound by you? So that is why we are using the word conflict, because there is no clear answer to such conflict. Now that will be decided by court, okay? Between the governor and the chief minister, the scenario which we discussed between president and prime minister, same can be the case between governor and CM. Consider that CM wanted a particular bill and this turned into act, but what happened when it is passed through state legislature, and then government is not signing it. Government is saying it is devoid of DPSP, against DPSP. So it will also represent constitutional conflict at state level, okay? Now comes the point, utility of directive principle state policy. Use kya hai? What is the use? So you can here check out the comment which was made by MC Settlewood, was a former Attorney General. So what he said, DPSPs although confer no legal rights, create no legal remedies, are significant and useful in following ways. No legal right are there in DPSP. You cannot go to court. Legal remedies are not there. For example, in fundamental rights case, there was constitutional remedies mentioned in Article 32. There is no such article, no such remedy present in DPSP, yet they are very much useful. Number one, instrument of instruction. These are like instructions to state. The state will look into DPSP while making their policies in order to establish new social economic order. We are using the word new social economic order because socio-economic rights are going to be ensured by state following these instructions. Now there are these 6 points. One, help the courts in exercising their power of judicial review. As I told you, that what court do in Champakam Durai Rajan case, thereafter this Golaknath case. So court was reviewing the status and this conflict between fundamental and DPSP. For example, if government has made a policy regarding, say, abolition of zamindari, like Jawaharlal Nehru government did. So now validity of this law was questioned in court. There was a strong lobby of zamindar which were against this government action. How can this happen? Because this right to property is a fundamental right. Now what government said in court? Government said, Honorable Court, please look into the provisions mentioned as DPSP under Article 39B, 39C. On this point, court said, yes, this is the direction given by Constitution to the state that they have to take action for equitable distribution of resources and restriction of concentration of wealth. So Zamindari Prohibition Act is very much in consonance with 39B and 39C. So here, Supreme Court said, okay, we are using this DPSP for judicial review purpose. So this is the utility. Please remember this is an important utility. Second, background to all state action, legislative and executive. Legislative and executive actions by state, they are taking inspiration from DPSP, what needs to be done. Direct. Third, facilitate stability and continuity in the domestic and foreign policies. You know that Article 51 talks about foreign policy, and from Article 38 to Article 50, we talk about various provisions where state policies, how state policies should be, it is very much clear. So it means no matter which government is in power, but every government will see our job is to look into DPSP and define our actions accordingly. So there will be a coherence in, you can say, state policies. Then comes this fourth point, enable the opposition to exercise influence. Now this point and this point is interconnected, fourth and fifth point. So what does it mean? That opposition can ask question that this should be done by the government as it is mentioned in DPSP. But what you are doing? You are not doing this. You have made no policy with regard to right to work. You have not made any policy in this year with regard to giving, you can say, good environment to worker. You have not made any such policy with regard to protection of environment. So from where this opposition party in the house is getting its comment or the point of analysis, they are getting it from DPSPs. Okay, and this can be these DPSPs can also be a check on performance of the government. that, okay, these are the DPSPs, what you have done in this regard. So it can be used as a test. Okay. Then comes the last, supplementary to fundamental rights of citizens. Some rights you have got in FR and other rights you can got as the extension coming from DPSPs. Okay, so these are the 6 utilities. Please remember, this can be asked in prelims as well as mains. Okay. Now, conflict between fundamental rights and DPSP, another famous part. So this conflict was visible in the year, in the first year of the enactment of Indian Constitution. And then we saw this Champakam Durairajan case 1951. In this case, Supreme Court was in, you can say, a pacify mode. The pacify mode means they were not that much activist like we see Supreme Court as of now. One reason is Jawaharlal Nehru, the Congress government, the kind of legitimacy and support they were enjoying in the country. So at that point of time, what Supreme Court said, fundamental rights are over the DPSPs. Means FRs are above DPSPs. But another important part is fundamental rights could be amended. And this changed the whole picture. It means they accepted FRs are above DPSPs, but FRs can be changed. So if FRs can be changed, it means FR can be removed also. If any fundamental right is obstructing the path of making law by the government, what government is going to do? A government can remove this fundamental right. Let's remove this. And this is a solution coming from the interpretation from Champakam Durairajan case. And this is exactly what government did. First Constitutional Amendment Act. The Parliament made first Constitutional Amendment Act 1951, Fourth Amendment Act 1955, Seventh Amendment Act 1964 to implement some of the directives. It means government wanted to bring these policies. For example, these land sealing laws, Zamindari Prohibition Act. In short, we can say land reforms. Now, some fundamental rights are obstructing this part, so they change the status of these fundamental rights. Right? They added certain laws. For example, we discussed in 31A, B, and C. Right? We also discussed later about 9th schedule concept emerging from this particular time. Right? So this creativity was actually coming from Parliament because this scope of amending the fundamental right was there. Until now, there was no concept of basic structure doctrine, which we have as of now as an outcome of Kesavanand Bharati case. Now coming to the Golaknath case 1967. And this is totally different from what court observed in this earlier Champakam Durairajan case. There, what they said, Parliament cannot take away, abridge any of the fundamental right. So it is like limitation was imposed on Parliament. You cannot do this now. You have done enough adventures in your life. Now you cannot do that. Fundamental right cannot be amended for implementation of the DPSP. This is the application part of it. So now it is like here the hands of government were actually open. But here the hand of government was in restriction. So do you think government will restrict so easily? No. Because Parliament has the power to amend the Constitution and Supreme Court is there to guard it through various interpretations. But ultimately they have to interpret what is written in Constitution. And this is exactly what our Parliament did through 24th and 25th Constitutional Amendment Act. For example, 24th Amendment Act, what they did? Parliament has the power to abridge, take away any of the fundamental rights by enacting Constitutional Amendment Act 368. So they even amended the Article 368 because Article 368 earlier it was saying process of amendment. Now it was power of Parliament to amend the Constitution. The title was changed. And it clearly mentioned if any amendment is done exercising the power of Article 368, then it will be beyond the purview of judicial review. Right? So now by this particular amendment, now Parliament was actually got the power in his hand, right? So you can think it is a volleyball game which is going on. Now 25th Amendment happened, inserted a new Article 31C, and 31C clearly mentioned whenever we are going to make law, taking inspiration from DPSP 39B, 39C, and even if that law actually contravene provision of say Article 14, Article 19, then also Supreme Court will not declare this, or this particular law will not be declared as void. It means Supreme Court now cannot say this law is null and void, because this is clearly mentioned through amendment. Okay. Now, this we also discussed when we were discussing 31C. Now, laws made under 39B, 39C shall not be reviewed any court of law, no judicial review. Right? Look what was happening with the power of judiciary at this point of time. Unconstitutional under Kesavanand Bharati case. Kesavanand Bharati case said, "Ye kya ho raha hai? This cannot happen." In Kesavanand Bharati case, Supreme Court said, "Who is the boss? We are the boss. Supreme Court is the boss." So how they did that? They used this judicial creativity, and they brought basic structure doctrine. And when Parliament started asking, government started asking, what is this basic structure? We are also lawyers, and we have read Constitution multiple times, but it is not written there. So Supreme Court said, we can do that because we are the guardian of Constitution, and there is no limitation on the power of Supreme Court to guard Indian Constitution, right? And when Parliament asked, so, ठीक है, this is basic structure, you are creating it, but give us the list now. What constitutes basic structure of Indian Constitution? So as a reply, Supreme Court said, for this, you have to wait. Now Parliament asked, till what time? They said, it will be decided on case-to-case basis. We will analyze this, our bench will analyze this, whether this should be considered as basic structure or not, and then we are going to pronounce the judgment. So in Kesavanand Bharati case, Supreme Court said, you are fighting for amending power of Constitution? Parliament said, yes. What fight? This is ours, as mentioned in Article 68, and we also amended Article 68. Supreme Court said, we have given you this power. We have no conflict with you. You have ultimate power to amend Indian Constitution. Parliament said, oh, it means conflict resolved. Then Supreme Court said, just listen to us completely. Supreme Court said, you can amend Constitution. Even you can amend fundamental rights. Please remember, if question statement says whether fundamental rights can be amended, whether Parliament has power to amend fundamental rights, you are going to answer yes. But this cannot abridge the basic structure of Indian Constitution. It means by using this line of basic structure of Indian Constitution, the Supreme Court brought the whole game in its favor. And who is the ultimate boss? Supreme Court said, we are the ultimate boss. Now, Minerva Mill case. Fundamental rights conferred under Article 1419 were accepted as subordinate to DPSPs, right? As specified, because it was mentioned in 39C as well. Article 31, right to property, was abolished by 44th Amendment Act. We also discussed this when we were talking about fundamental rights. Balance between fundamental rights and DPSPs. Now from Minerva Mill case, a new hope was given to this conflict. That rather than considering that who is superior, who is inferior, we should consider the complementary nature of these parts of Indian Constitution. Okay. So now these are some divisions between DPSPs and fundamental rights. Now, when it comes to fundamental rights, these are negative. So you can easily remember all of these differences by remembering one keyword. Negative means you can enjoy your fundamental right when some limitation is imposed on state. Okay, so that is why nature of these rights is negative. When it comes to DPSPs, they are positive. Positive means a state has to perform these actions, then only these socio-economic rights can be ensured. Next, they are justiciable. It means you can go to court. They are non-justiciable. NJ. Aim is to establish political democracy. I mentioned this when I was mentioning a point by Dr. B.R. Ambedkar. These are there for socio and economic democracy. Now they have legal sanctions. They have moral and political sanctions. Legal sanctions means if you don't ensure this right, then people can go to court. Legal power is there. But here we have moral and political sanctions. Means it should be the duty of state. It should be the political reality that state will strive to make these provisions work. They promote welfare. of individual. Please remember, they perform welfare of individual, they perform welfare of community. Means, welfare of community means they have socialistic tendencies. Means society, welfare of society should be primary. And that is why we say that Indian constitution is right mix of different ideologies coming together. Okay, many nations, they actually recognize themselves, we are liberal, we are socialist, and what we can say, we are having right mix of different ideas so that best outcomes can be achieved for Indian people. They do not require any legislation for their implementation, means automatic, they are automatically applied. But when it comes to them, they require legislation from parliament, right, as well as administration, means executive, because when it comes to DPSPs, so they're applicable on legislature as well as executive, right. The court are bound to declare law violative of any of the fundamental rights as unconstitutional, invalid. So because this is mentioned under Article 13, right, but the court cannot declare a law violative of any of the DPSP, okay, because they are not justiciable. And the provisions, the kind of provisions they are, they do not stand for this way that no law can be made which is abridging DPSPs. And please remember, this is a crucial difference. A beautiful statement can be made by UPSC in your prelims, and many students are going to get trapped in this easy statement, right? Now, implementation of DPSPs. So do we have some examples where real work has been done by government? Yes, we do have. In last lecture, when I was discussing different features of DPSP, I was mentioning certain schemes, laws, which got inspired from these respective DPSPs, right? Same. For example, Planning Commission was made, now it was converted into Niti Aayog, and they are working in this direction. There are so many initiatives of Niti Aayog which draw inspiration from DPSP. So at this point, tell me, what do you know about Saath initiative of Niti Aayog? So Saath initiative of Niti Aayog, okay, and from which DPSPs do you think it is connected? Quite trivial question. So you can only answer, UPSC is going to make certain statements as well, but you can only answer this question when you have two understandings. One, what is Saath initiative? What are the objectives which are mentioned in Saath initiative? And along with this, you also need to have understanding, oh, where DPSP stands there. So those who are not aware, you should check. Saath initiative talks about education and health, working for increasing the outcomes of states which are considered poor in these sectors. So now how you can connect? Oh, DPSPs, which mention about health and education as a priority of state policy. So if you got it, this kind of dimension question will be asked. If you got it, mention got it in comments. Abolition of intermediaries like Zamindari, Jagirdar, Imamdars, clearly visible, coming from 39B, 39C, right? Cooperative farming, we discussed 97th Constitutional Amendment Act, adding this, that cooperative societies, maternity benefits, mindset, community development program, and so on. So we have numerous laws and policies which got inspired from DPSPs. So by this discussion, I hope now all of you are clear to this point, that you cannot say that DPSPs, since are not justiciable, they are not having any real value. You cannot say that. You can see some real value. Okay. Now, directives outside DPSPs. So if a statement is made that directives to state are mentioned only in directive principles to state are mentioned only in part 4 of Indian Constitution, do you think that statement would be true? Yes or no? Come on. Some students might say, oh sir, this statement is quite true because there's a dedicated part for that, DPSPs. So DPSPs are mentioned only there. So I've not said that they are present only there. Means there are some directives to state regarding some actions which are present beyond this part 4 also. Okay, so you should be clear on this. For example, claim of SCs and STs to services, their claim to services. Appointment to services of the Union States, this is mentioned in Article 335, Part 16. So don't you think this is a directive to state for welfare of this section? But this is present in Part 16, not Part 4. Okay, so another instrument in mother tongue, this is another directive. The language is directive in nature. Instruction of the mother tongue at the primary stage of education to children belonging to linguistic minority group, 350A in Part 17 in every state. So here also there is another directive. Then development of Hindi language, duty of union, 351, Part 17. Okay, so these are the directives present beyond Part 4. I hope you will remember them. Okay. So now you can shoot me a message on Insta or Twitter if you find any doubt whatsoever. This PDF will be available in Telegram group Shashank Tyagi for you. So I wish you a lot of success as soon as possible. See you in the next session.